In order to use guided choice dispute resolution to resolve design and construction disputes, you really only need one essential element, and that is agreement by the parties to use a qualified mediator as a facilitator of the process. This is going to be somebody who is steeped in the principles of guided choice dispute resolution, which, as I've discussed in other videos, isn't necessarily something that is unique to guided choice, but is rather a collection of the best practices, which in my view are used by the best mediators. But you need to have a qualified mediator who's able to run this process. And even though this person works essentially as a mediator, and you'd even call them a mediator, in guided choice, the mediator does not focus initially on settling the case. In other words, the mediator's focus is not on where should this party make their first demand, and where should this party make their first offer, and how can we split the baby and horse trade our way to a resolution. Instead, the mediator works with the parties first before we ever talk about negotiating dollars, to facilitate a discussion on procedural matters around the question of why were they unable to resolve the dispute themselves? What is creating the impasse? What is necessary to break through the impasse in terms of information exchange? How can we tell whether parties have received enough information a month from now so that they're able to engage in a fruitful negotiation, or whether we're going to kind of continue working on matters of process to get them to a point that they have enough information to be able to make a strategic decision about whether a settlement or fighting on is in their best interest. Now, the parties really, again, they need to select a qualified facilitator who really understands these principles. And this is somebody who, isn't necessarily going to have guided choice on their resume, although there are those out there who are using the phrase, which was coined by my former law partner and current mentor, Paul Lurie, this guided choice nomenclature, but certainly a wide variety of mediators have, all of the essential tools in their toolkit. And this is somebody who, is going to understand the importance of procedure and not convening the parties too early so that they have a fruitless, premature positional negotiation where we set a date for one party to take an extreme settlement position and the other party to take an equally extreme position, and then have everybody leave angry. But somebody who has a broad range of experience with many forms of dispute resolution systems, so that he or she could take the best, of each of them, whether it's mediation, conciliation, early neutral evaluation, adjudication, in litigation, dispute resolution boards, arbitration, hybrid methods of binding and non-binding dispute resolution. You're going to want somebody with a very broad range of experience in order to effectively implement guided choice, because this mediator needs to be creative and they need to be prepared to play a different role than a traditional mediator. Again, we're not just going to pick a mediation date and have everybody come and take extreme positions and bang our fist on the table and eat a Danish and leave angry. We're not just going to have this shuttle diplomacy on a single day of mediation. They need to be trained to understand the subject matter of the dispute, of course, but also they need to be trained and knowledgeable enough to investigate and diagnose the real cause of the impasse that the parties are at right now. And, just being a former judge doesn't give you this training. Just being an experienced construction lawyer does not give you this training. It is really the special neutral who understands enough about the psychology of dispute resolution on an individual basis, on an institutional basis, who understands that they have to investigate why are the parties here. What has prevented them from having a resolution in the past? Is it that somebody needs to hear an apology? Do they need to do a little bit of yelling for, catharsis reasons? Is there a misapprehension about something important? Is it because, they really know that they're wrong, but they just don't have the money to settle? Or maybe people who are involved in the chain of decision making feel like they're going to lose their job, if they're honest. And, so that there are these impediments to settlement which are not necessarily based on the merits of the case. this guided choice facilitator needs to understand that it is their job to investigate this, that they're going to want to investigate this, and to diagnose what is the real cause of the impasse so that they can create the procedure necessary to help the parties get through what's holding them up and to put them in a position to decide my strategic interests are to settle or not. And, if people decide that it's not in their interest to settle, there's absolutely nothing wrong with that. I'm certainly never going to split the baby or surrender my client's position simply in the interest of achieving early, cost-efficient dispute resolution. But because almost all design and construction disputes settle, but they settle too late after years of adversarial discovery and motion practice, after too much time wasted and too much expense, I'm really interested in finding out if whatever magic is going to bring about a settlement in a year or two from now, can we capture it now? Can we fast forward the tape to the end now? Can we take the short way around the block? And I think that this is why I am really looking for a good mediator. And on those bet the company cases, which are particularly consequential for my clients, I absolutely will go outside of Chicago. I'll go all over the country and I will interview people who I believe not just are wanting to say the right things to me, but through their scholarship, through their reputations, through information that I can get about them, makes me believe that they actually deeply believe in some of these principles. And I'll bring them to Chicago, and I've had great success in importing mediators into Chicago from all over the place, and also using great design and construction mediators here in Chicago as well to implement these processes. And the training and the mindset that these facilitators need should teach them about the psychological factors of dispute resolution, such as risk attitudes and emotions. Again, things that go beyond the merits of the dispute, things that go beyond the substance of what people tend to put in their legal briefs. What are the business consequences of settlement? Is there any particular animosity between the parties? Will one party suffer extreme financial difficulties if they settle? And the reason for lack of settlement isn't what they're arguing on the merits. It's just because they can't settle now. And, sensitivity to cultural and gender issues, can be very important. And lawyers, I think, mistakenly sometimes tend to think that settlement decisions are logical when in fact, it often involves a large emotional component that our clients are going through. And it may be the case that most cases which, go to mediation, and again, mediation is no panacea. I've had my fair share of very frustrating mediations where everything about it was bad. But mediations that don't tend to settle, that don't tend to result in the case of settling, they're often set up wrong. And they often overlook, the emotional, psychological, organizational factors which tend to drive the parties apart. And so, a good facilitator of the guided choice process is going to be thinking about these things. But he or she also needs to be a good salesperson of the process, because even if I have a mediation clause in a contract that was signed a couple years ago, and I can force my opponent to participate in a mediation, that doesn't guarantee that the lawyers on the other side are going to be willing to engage in earnest in the process. And so finding the right mediator who is able to get in touch with the other parties and convince them that no one's trying to force their hand, that this is a good thing, it's process oriented, what do they have to lose? Often initial discussions with guided choice mediators do not require a commitment to exchange settlement offers, and they often don't even include a commitment for there to be an in-person mediation date, but rather just an agreement to have some discussions with the guided choice facilitator to see whether he or she is able to come to some understanding with the parties on both sides that they can play a useful role in the process. And so, I am a big fan of guided choice dispute resolution, and beyond the advocate, beyond my job in finding the right mediator, is engaging somebody who isn't going to give me lip service and say, yeah, I'll run whatever process you want. I really do look for those neutrals, those facilitators who believe earnestly that early cost-efficient dispute resolution is possible. It's favorable. It's what our clients want, who believe that adversarial information exchange through litigation and arbitration, while sometimes necessary, is not always necessary, so that when I bring this person in, he or she can be an advocate to creating a good process rather than a mediator who I need to push and shove and say, why don't you look at this or look at that, or the other. So find the right guided choice facilitator, the right mediator, the right neutral, if you wish to pursue early cost-efficient dispute resolution through the guided choice process on behalf of your clients.